use WKU for this task force meeting. And all of you all know this by now, but if you're seeking reimbursement as task force members, you can reach out to one of our staff to make sure that that's taken care of. And if you all have any questions, as always, you can talk to our staff as well. If we have any public participants in person or Zoom, thank you guys for being willing to contribute. There is a sign-up sheet in the room as well. If anybody is here and wants to talk at the end of the meeting, and remember, as always, you can submit written comments to searchwarranttf@ky.gov. All right, turning to old business. You all should have the meetings in front of you from the August meeting. If there are any changes to the minutes, please let me know. If not, then I'd like to entertain a motion to approve the meeting minutes for August.
Move approval.
All right, can I get a second? All right, seconded by Ms. Denise Bentley. And all those in favor?
Aye.
Any opposed? Okay. Motion to approve the minute passes. Okay, jumping right in to the business at hand. We will have, did somebody just join? We will have a presentation from the securing committee, and I believe Judge Cunningham is going to lead that conversation. Obviously, we have a memo that's been provided to us in advance of any presentation. Judge Cunningham, I will turn it over to you for your presentation from the securing committee.
Thank you. I'm going to speak loudly, and is that too loud for anybody or not loud enough for anybody?
I think you're good on our end.
Okay. Then let me begin by saying that I simply attempted to kind of crystallize the discussions that we had in a couple of our meetings, and I'm sure you'll recognize a lot of what we talked about as stuff that were talked about even in the broader committee, the whole task force. And the challenge we found as we tried to figure out how to do things better was that one person would say, here's what I understand about how things work, what the results are. And somebody, if they had a somewhat differing perspective, we really don't have any data to be able to really assess what really happens. We all have parts that we play, and we all know what it looks like. It reminds me of that old story about a bunch of blind monks coming upon an elephant. All touched different parts, and they thought they had different things because they didn't see the whole parts. But Ramon McGee in particular spent a lot of time trying to see if he could round up some folks at some of the universities who would be willing to put some time and resources towards looking at data and compiling some stuff and giving us some clues about how things have been done in the real world. And the simple truth of the matter is we don't have the ability to do that right now because of so much of what happens with search warrants, particularly if they never get accepted or never get served in a case that goes to court. We just don't really have that readily at hand and compilable. So our first and we think important thing is that we have to have a way of keeping track of this stuff going forward. So the presentation that we had about search warrants being dealt with through the process where the fellow from Westlaw came, I think it was, no, Nexus Lexus, working on that for the Administrative Office of the Courts. They apparently now do our bench warrant process. We call it e-warrants. They're now trying to adapt that process to enable judges to approve search warrants through the e-warrant process. And we think that would be a good thing because we could then theoretically have a database to come back and look at things. That's going to be a bit of a lift in the sense that a lot of people will have to be retrained on how to do that. Somebody's going to have to be in charge of creating Although, again, it looks like that process is already underway. Somebody's got to maintain all that stuff and keep it humming. Decisions will have to be made about who can get into it and how to do it. But we think that's a process that the task force should recommend. And that recommendation essentially would have to go to all three branches of government, because all three branches of government would be involved in that. To some extent, there will be some financial commitment from the legislature, hopefully. And the executive branch will have to do some training with their people, and probably to some extent be involved in how it's put together. And then AOC, if it is in the e-warrant system, together with, I think, the state police will be managing them. So that's a pretty broad thing, but I think it's going to enable us going forward to be able to go back to our constituencies and say, we're going to make a process that will be transparent. And if somebody has concerns, there'll be a very real methodology for somebody to come back and take a look and see what's really going on. And we won't simply have anecdotal commentary from one constituency or another about what they think is happening. We can actually document stuff and look it up. If you look, I'm kind of skipping to the back, but I kind of did a very short and sweet spreadsheet kind of thing of what in theory could be generated through an e-warrant kind of process. You'd need somebody to start compiling this, and suffice to say, Charlie Cunningham, when he did computer programming way back in the day, we talked to computers with these cards with holes in them called Hollerith cards. So I'm not really, they tell me this Excel stuff's really easy to work with. I don't know, but there's people who know how to make it hum. And you could start having the ability to, I think, pull out stuff about, for example, mapping where are search warrants being, where are people going, what neighborhoods, probably down to zip code and maybe even tighter, but certainly by zip code, whose houses are getting looked into. You could tell what judges were signing things. You could see what individuals within any particular agency were actually going out and seeking. So we think that would be a pretty important thing for the task force to recommend. There will be details that will need to be ironed out, but broadly speaking, it holds the potential to help us going forward with giving the public confidence that this process is transparent. And by controlling who gets into it, we don't have to worry too much that targets of criminal investigations will know too early in the game what's going on. But if people need to look at it after the fact, that possibility will then be there. Having said that, even though we haven't been able to look hard at real numbers for how things have been done in the past, in listening to people, both our constituencies and people who have presented to the broader task force, there are a couple of things that have already come up that we feel should be adopted in some form or fashion by the full task force and recommended to the folks who would implement it. I know I was talking to Rob Sanders. He said all their search warrants get run through the office, through the prosecutor's office or the county attorney's office, depending upon what's going on. And I remember the feds, when the FBI fellows came by and talked to us, they said nobody goes to a U.S. district court judge unless they run it by the U.S. attorney first. So we believe that for the task force should recommend some degree of mandatory prosecutorial oversight in that. And I say oversight that it should be run by them. Suffice it to say that prosecutors have significantly greater training on what would constitute probable cause, what makes sense in a current constitutional environment in terms of what's enough to warrant a search warrant. And not that police officers don't get training for that, and you'd want them to have training for it, but for certain kinds of cases, it would seem prudent to have a trained attorney who has significantly more focus on that area of law, say grace over it before they take it to the judge. And one could make an argument that, well, that's what the judge is there for, to double check that stuff. And that may well be true, but there are people already doing this, which will keep us from thinking it's going to be a huge burden on the prosecutors. So that was something we thought would be helpful. Now, you can debate whether it should be every warrant like they do in Kent County, whether we would recommend from a statewide perspective that particularly if a warrant is understood to be going into someone's home, at a minimum, that kind of case should be looked at by a prosecutor. I know here in town, we have dogs sniffing all manner of packages that come through our airport because you has so many things that come through there. And we have a bit of an onslaught of search warrants that come to the judiciary here in Jefferson County because they want to get into a package because a dog alerted on it, classically. That's something that maybe we don't need to bother with having a prosecutor, because once you've done a couple of those, they're all pretty much the same. It's just the opposite if you're going into somebody's house. You might think, oh, I did one like this last month, but each of those really need to be thought through on a very individualized basis. So we could talk as a full task force about to what extent, in terms of a statewide mandate, we think is appropriate, but we would recommend we at least have a conversation about the idea of having a trained attorney / prosecutor say grace over some or all warrants. Furthermore, we heard some folks who presented to the full task force that, and I think, again, this was the FBI talking about how they do things, that even though they move, I remember he admitted to me they are notorious for moving slowly on their investigations, and they're never in a great rush. They're anxious to get it right and make it overwhelming. But nonetheless, they consider that evidence has to be the components of probable cause, the information they're acting on and requesting a warrant has to be no older than a certain age, or they rely upon it in the federal system. That you can't sit on something past a certain number of months or weeks and then claim that it gives you basis for going into somebody's house, for example. So again, that one can debate where one crosses a line from current to stale, but we should, as a task force, have that conversation. And to the extent we can come to a consensus, we have a recommendation that information beyond a certain date either can't be used or presumptively isn't creditable absent some special circumstances. And the only reason that I might raise that second idea with us, because to some extent that's if you're going to come and apply for something and it seems stale, then we need to talk about whether you just can't use it or there would be the opportunity to explain and give discretion to the judge to accept something out of town. But we should at least start putting some mile markers on there for how current stuff should be before you're going to use it for a search warrant. Then comes the other end of it in terms of timing. How long should you have to execute a search warrant, and what time of day should it be executed? That very much would be in the executing subcommittee's bailiwick. But if it's not a fixed rule, in other words, you can't execute it after so many days or weeks, you can't execute it except in this window of time during the day, then that's it. That's up for them to decide. Conversely, if the plan would be that we would make a recommendation that a search warrant should be executed within X number of weeks, or it ceases to be valid, unless you have some special explanation, well, that special explanation needs to be put into the affidavit. And therefore, we bring that to you all because it would be part of our process if we're going to set boundaries that can be exceeded based upon some kind of criteria where if these things exist, then maybe you could do it a little later, or more likely, as opposed to us deciding that a search warrant isn't stale after 2 months based on X, Y, or Z. What is more likely is we think search warrant should only be executed during certain hours of the day, unless, and then there might be some kind of limited exceptions where we would say these things apply, then maybe you can show up at a different hour, and we'd have to figure out what that might be. That would come back to what needs to be in the affidavit for the purpose of securing the warrant. Well, those are the things that, at least that I was able to take away from our meetings, and hope that that gets people thinking a little bit about some concrete steps that we can take. And I would open it up now to my colleagues on the subcommittee, if any have some additional statements they want to make to kind of flesh out this admittedly kind of skeletal information that I presented. So I assume everybody got the memo. That anybody who's sitting there scratching their head thinking, what is Cunningham talking about? Okay, good. So I see Ramon is the top guy on my screen. So I don't know, Mr. McGee, do you have anything you wanted to add?
Well, very briefly, Judge, and I think in reviewing the summary that you provided, Judge Cunningham, you did a great job in terms of synthesizing what we had discussed as a subcommittee regarding the recommendations to the larger task force. The one thing that I would note is that we did want to try and accumulate a large amount of empirical data so that we could have good recommendations to go forward on any changes that we thought were necessary in the securing portion of the search warrants, particularly how the affidavits are compiled, what data is used, and how judges review those. The problem has been what Judge Cunningham indicated, that when you go back and try and collect data, and we had talked about a 3 to 5 year period, getting access to any existing data proved problematic. One, it's not stored consistently in the different geographic locations that we have to address. Some judges keep copies of their warrants, some judges don't. Different AOC offices don't necessarily maintain warrants that are applied for, as opposed to those that are actually granted. So getting access to the data was problematic. And then just the sheer amount of work that's necessary with the different personnel we need to compile and analyze the 3 to 5 year data set also proved somewhat daunting. As Judge Cunningham indicated, we had reached out to several different universities and agencies throughout the Commonwealth, specifically the School of Criminal Justice at the University of Louisville with Dean Thomas Hughes, who was immensely helpful in his recommendations, as well as Dean Crawford at the Brandeis School of Law. So just getting the personnel in a position to be able to analyze any data we could collect was an additional burden to this task force, given the time limit that we have. So the recommendations that are coming from the Securing Committee acknowledge what we anticipate the data might indicate, with some recommendations about how to avoid some problems that we saw in the securing process moving forward. And the idea that we would superimpose that on the existing electronic warrant system, I think, is a phenomenal recommendation. And it's something I'd encourage the larger task force to adopt. But I appreciate your work on that, Judge Cunningham. It does, I think, fairly represent what we had discussed in our subcommittee.
And I've kind of saved my end of the future recommendation from the second page. I had a bullet point number 6 on the outline. I'll come back to that. I've got Mayor Gregory also up on my screen, at least in terms of there's a panel that says Mayor Gregory. Did you have anything you wanted to add?
No, Judge, I think you all have done a great job. And of course, you and Mr. McGee have led our committee and done so in a great fashion. I think you've summed it up well.
All right, Denise, what about, I know you've been our leader, and I don't want to steal any thunder if you've got some ideas.
First of all, Judge Cunningham, thank you. I know we've texted back and forth in between your days on the bench and me at City Hall, and I want to thank you because it did take a lot of time for you to put this together. I agree with Ramon in wanting the past data to move forward, but understand the obstacles. I think we're moving in the right direction. So moving forward, we have information so that we can develop some type of statistics in the future when asked. I do know that Nikolai had a question or concern, so I'm going to yield to him. Again, thank you, Judge Cunningham.
Thank you. Commissioner Gillick?
Yes, sir. Thank you for your work on this, sir. The only concern, which at this point in time, I wouldn't really say it's a concern because I think you spoke about it and addressed it, is that any kind of hard, fast rules with the search warrants can be problematic, times a day, and whether or not there would be a need to serve it past a certain period of time after it is secured. And so long as there is a means to articulate a specific need, as long as that's addressed and you address that, so I no longer have any concerns. But thank you.
I give you a perfect example of that sort of issue, and that is no-knock warrants. There is a school of thought that there's no need to ever have a no-knock warrant, and we should just ban them flat out. And then there's a school of thought, and that is the school which won out in the legislature this past session, which is, broadly speaking, we don't like them, but we will acknowledge that under certain limited circumstances it may be necessary. So we can have those conversations about these other things, but that is part of what we need to decide. Do we want to have simple, straightforward deadlines / dictates, or do we want to occasionally say, however, in limited circumstances, do something different? So, and then last but not least on the committee is David Nicholson. David, are you there? I don't see you, but.
Thank you, Judge, and echo the same sentiments of our committee members. I think this is an excellent beginning. I think we have articulated, based on the information that we've been given and we understand. I do find it very helpful, Tennessee's presentation and the FBI's presentation, to give us a good framework. And I think when you bring home item number 6, that really will ensure on the securing of a search warrant that there's good accountability, and particularly when we get the data, and can have data elements built in, at least moving forward, that we know, and the accountability is then very transparent. So I thank you and my fellow committee members in this task force for the process.
And David and I did not rehearse that transition from everybody weighing in and then it's going to section 6, which is that as nice as it will be for this task force to issue some recommendations, in an ideal world, there would be a process whereby how search warrants are being secured, approved, and executed going forward could be reviewed as opposed to waiting for some catastrophe and people say, oh my goodness, there's something needs fixing, let's get on it. So the one thing I was aware of, to use as kind of an analogy for that, is I know when in my community, if we have a young person die that had been in the state system somehow, some way, either juvenile justice or Department of Health and Family Services, if they had been caring for this person somehow, foster care, and that child passes away, that death will be reviewed. And I don't remember how frequently that committee gets together, and thank God it's not like they've got to look at 17 of these every time they get together, but there sadly are a fair number of them on an annual basis that require some attention. And they do that with the goal of, is there something we could be doing better to keep this from happening? So this is a really broad concept. I don't think we necessarily are here to say this is what it ought to look like. I don't even have the sense that we've heard from other states or entities who are doing this, but in an ideal world, we might want to make a recommendation to the legislature that something be done that wouldn't give, and whether this would be, and again, I don't want to get political about it, whether this should be the Attorney General doing this or the governor's office or whoever, but ideally probably a combination of entities, much like this task force where you want to bring people from a lot of places. And we can never forget that I can sit here and talk to you for a long time about how we do things in Jefferson County. I can assure you that has absolutely no bearing on how they do things in Boyle County. And I remember talking to Rob Sanders and how he does stuff in Kenton, which is kind of, it's a large county, but it's not like Jefferson. So we have to remember we're talking about 120 different counties, and we're talking about police agencies within those communities that sometimes are even smaller. So we have to try to, I think, have a plan going forward where we can hear a lot of voices and make sure that we're trying to stay out on the cutting edge, because that's what we're trying to do here, is make sure we're using best practices, and those will change over time every once in a while. And ideally there'd be a process where we can, let's face it, a lot of the people who are negatively impacted by this process don't have much of a voice. Damon Preston and Ramon McGee are their voice here. They've got a lot going on, and they'll get back to us when there's a problem, but ideally, all of us would be looking at things going forward, and particularly once we think we'll have some data for them to actually chew on. That's a bigger lift, if you will, but something we would hope that the broader task force could entertain and talk about and perhaps come up with a plan. So with that, I will open the floor up to questions from the balance of the task force. Damon Preston, you raised your hand and I actually see you, so.
All right. Judge, thank you. And thank you to the committee for the great presentation and the good ideas. A couple of follow-up on some of the suggestions. And the answer to this may be your last point, this review panel, if it can be created. But the question is, did the committee give some thought to how that data would be accumulated? Because the data would certainly be helpful, but did you give thought to, would it be, state police? Would it be AOC? Would it be a group within the Justice Cabinet? Who would accumulate that data? And possibly if this review panel exists, maybe that would have a small staff that could be the answer to that question. But did you all have that discussion?
I think I just mentioned the fact that you wouldn't need a rocket scientist to compile this stuff. Clerical staff, and I don't treat that lightly because I know how much the clerks in my building get specialized, and then become invaluable. So yes, you ideally would have a couple of people who are in charge of overseeing that. Now, had we actually talked about, and I will just say, Charlie Cunningham is notorious for having solutions to every problem in the justice system. Problem is, my solutions always cost money. And then people say, okay, well, that's fine, Cunningham, get the hell out of here. We wanted free solutions. So this is a perfect example where it would be fairly straightforward to figure out a good system, how this data would be compiled, who would store it, who would access it, who would put it in a format where a task force could look at it on a regular basis and see what's going on. But that will require a little bit of money. So I can fix that. I have a little bit of resources. Here, when you look at that spreadsheet, and this, when we talked about it, really, the real art of that is going to be that last column, results. Everything else is almost black and white when you think about it. The date that it got executed should go into the system, and that should be there for you. The date that it was issued certainly ought to be in there, and so on. What would require a little insight, if you will, of your clerical staff would be knowing how to put down what the results are. Now, you could say, well, that's not mission critical for the things we want to look at. I would suggest to you down the road, people are going to want to know what were the results, what happened with that. And that's going to require a little more of whoever's going to be looking at it down the road, telling the clerk, here's the kind of things we want an answer to. And it may not be the kind of thing that when they go into e-warrants and pull all the other stuff and fill in all the other columns in the spreadsheet, that's going to be more complex. And I don't know that we have an idea in mind on that, but that is a really important column, but it's going to be the toughest column to figure out how to fill in. Now, you can make it simple. You can, for example, say, did a lawsuit follow? Was there eventually a lawsuit brought over this? Then you could at least know how many search warrants we issue that never even lead to anything. And that, if you started finding out half your warrants don't lead to an indictment, you might start wondering, are we going around kind of, that's important to know, I would suggest, but it might be more important. I don't think it would be that. I certainly would be shocked if half our warrants aren't leading to indictment. Having said that, you probably want a little more precision in terms of results. And I'm not really, I don't think to be honest with you, what have we met? A whopping hour and a half, maybe, of all of our subcommittee meetings. So I'm going to say we got to go first. Happy to take the lead, but I'm not sure we've work through this as much as we could. But you are exactly right. The art of that is going to be who's actually compiling that and then putting it into a format that a broader group like this could actually evaluate and make some recommendations based on.
I could ask one more question, Judge. One of I think you made reference to the no-knock warrants, or somebody made reference to the no-knock warrant statute. One of the things that I thought was a good idea in that bill that's now, part of it's an evidentiary rule, is the fact that the warrant for those, in that special circumstance, the warrant had to be reviewed by, I forget the language, but essentially the police chief or the deputy chief or the shift leader. Did you all have any discussion on whether to require that in some circumstances, perhaps if you're going to go outside the prescribed hours, or if it's a residence with children, any like heightened concern circumstances where maybe we want to put an additional protective measure such as supervisor review in those circumstances?
I think it's fair to say we've had broad discussions about that. I can't say that we've come to a consensus even within the subcommittee, because when you think about how many different things we've talked about so far, and candidly, a lot of our initial discussions was focused on what is doable in terms of compiling real hard data. And sadly, while we spent a lot of time on it because we thought it was really important that instead of just coming in with anecdotal, Charlie Cunningham saying, we know judges know what they're doing, if they issued a search warrant, it's probably great. Or Ramon saying, look, I can tell you, I've got clients getting rousted with bogus stuff. Neither of us wanted to come and do it on it. We wanted to be able to say, here's what the data shows. Well, probably our first meeting, Ramon, Denise, I think we spent most of our time talking about how might we go about that. And then, like I say, Ramon in particular did some research between meetings, but the bottom line was it just isn't workable with what we have right now. So then we talked almost, I won't say in passing because that sounds like we didn't put much thought, but we then condensed the balance of our discussions pretty tightly into what are some things that the broader task force needs to talk about. So I will say no, because if the thing we probably spent the most time on was what can we actually get our hands on? And the bottom line was not too much. Now, that's not to say like, you can go see David Nicholson and say, David, we need to see a copy of every search warrant that got issued in Jefferson County for the last 3 or 5 years. He's got them, but doing much with it is a Herculean task. Not to mention, he doesn't have the ones that got rejected. So if that was important to you, those aren't there. So just to pick one example. Other questions? And if you're raising your hand, I might not see you, so just speak on up.
Judge, Sheriff, this is Walt Scholler from Bullitt County. I'm curious, the search warrants that Judge Goodhand does not issue, what becomes of those?
Well, in my experience, law enforcement looks at me quizzically and with a little bit of hurt in their heart and grabs them and walks away. So that's what I'm saying. I guess in theory, I could say I'm holding on to these and we could create a folder of rejected ones. I mean, that could be done. But if we go to the e-warrant system, it'll be simple. They put it in and then we'll know either it got issued or not, and it would be there. But right now, and again, I can tell you what might happen for me, but that doesn't mean that even all my colleagues in Jefferson Circuit Court, much less Jefferson District Court, are doing that. And so, because right now, I'm not aware of a protocol that says this is what you should do if you reject a warrant, other than not sign the doggone thing.
All right, sir. A follow-up question about that.
Yeah.
I have made open records requests of the Administrative Office of the Courts and was advised by both them and the Attorney General previously that the Administrative Office of the Courts is not subject to the open records statute. And so am I to understand from what you said previously that if a search warrant is issued in Jefferson County at any rate, there is a place at the courthouse that the circuit clerk has that search warrant, and I and any other citizen of the United States or resident of the United States has the ability to go to the circuit clerk's office and get a copy of it?
I'll let David answer that. I believe that to be the case. David?
Thank you, Judge. Sheriff, yes, that is correct. An executed search warrant has to be submitted to the office of the circuit court clerk, and most of the time they are matched into the case. There's an open case, subject to it not being a sealed search warrant. Now, if it is sealed, then obviously it's not available to the public or any individual unless the court unseals it and says that we could release it. As the judge said, we currently have had in the last 12 months a significant presence of attorneys and media going through several thousand executed search warrants.
So, and finally, this is my last question, and it may, at the risk of appearing to beg the obvious, I don't know the answer to this. The data that you all are talking about collecting and being looked at from time to time, I presume, across the state of Kentucky, what is the benefit of 5 years from now looking back and seeing that there were 52,000 search warrants issued in the state of Kentucky and there were 23 that were not issued or this or that? Just that data, what's the benefit of improving, or how is that going to improve our the securing, the reviewing, or the execution of the search warrants, as opposed to the risk that it runs of being a tool to use to fan the flames of discord?
Well, my argument would be that we should not presume that if we simply say, trust us, everything's working out fine, that means there won't be discord. I think if somebody could 5 years from now come in and show there were 52,000 warrants that got issued in the state of Kentucky and only 23 that were rejected as not providing probable cause, that would give somebody some ammo to say, we're doing pretty good. Arguably, to give you an example in Jefferson County, and in Bullitt County, you probably have, 2-3 judges who are looking at search warrants, and probably on a fixed rotational basis. In other words, you don't sit around and think, do I want to go see this judge or do I want to go see that judge? They probably have it set up that you know exactly who you're going to go see on a particular day. Well, in Jefferson County, we've got a boatload of judges, and some people think that police officers go judge shopping and that they have certain ones they like. And I will tell you, I've had police officers come to me and some of my colleagues in circuit court and say, we come to you because you read it. We didn't like some of the judges who just basically take it and sign it and send them on their way, who clearly, to their way of thinking, hadn't even read it. And they actually want you to read it and make sure that you've got it right. So that would be beneficial if this data could show that the workload is being spread around pretty rationally amongst judges, just to pick one example of what the data could show. I would tend to agree with you that it's not going to show many that got rejected. And whilst one could argue that must mean we're doing the process really well, if you don't trust us, it'll just mean they'll say, well, see, you'll sign any damn thing. And yes, you've rejected 23, but so what? So I'm on that particular example, I'm not convinced that will necessarily keep everybody believing, but at least if they know we're keeping track of it and we know how many got rejected. And I'll tell you what with me happens more commonly. I will read a very lengthy, and particularly when they're looking for phones, because they put all manner of page after page of stuff about why they want to get into a phone generically. Here's how phones work. Here's what we could find in a phone. Here's the information that will be available to us if you give us a search warrant. And then they come to why this particular phone number, and there's like 2 lines of why they want to get that phone. And I'll say, I don't understand why you want to get into this guy's phone. And then they'll say, well, because of such and such and such and such. And I'm like, do you understand that's a critical part of your probable cause here? You either need to go back and rewrite it, putting that in, or what we'll typically do, we will sit there and write it out by hand on each copy identically, make them initial it, I initial it, and then I approve it after they swear that's true. So that's another, with this e-warrant system, what I think will end up happening is they'll submit it if a judge rejects it for that kind of reason. I don't see the probable cause here. There won't be this having a conversation and potentially filling out on the paper a better iteration with more stuff in there. They'll have to go back and rewrite the doggone thing. And the judge, I guess, in theory could say, I'm not seeing any, why are we looking at this particular phone? So that may be one reason to look at things going forward, because there may be some of that it'll be, people will get frustrated at that inability to fix it right away. But we will have a track record of some got rejected and then fixed, if you will.
Judge Cunningham, I want to piggyback on his question. I didn't quite understand what you meant by fanning the flames, but I think it's important to collect history and data because that gives us an insight on a lot of things, not just the things that Judge Cunningham pointed out. It tells me, as a resident of a community, if I can look at zip codes that have high numbers of search warrants, it tells me about the socioeconomic status. It tells me what judges freely sign search warrants, what police officers freely go get search warrants. So I think that the data is very important, not to fan a flame, but to have a history and be able to pinpoint issues or problems if they exist.
And if I could just follow up very briefly on that, what both Judge Cunningham and Denise Bentley indicated, I think speaks to a larger issue. Whatever the focus or purpose of the task force has to be, we've got to move beyond the point where we rely on conjecture and speculation as to whether problems exist. The whole point of collecting the data and ultimately making the recommendations is to identify problems and address them. So we can't really be afraid of what the data might reveal, or that the data will be available for particular political entities or social entities to use as a basis to what you described as fanning the flames. And I'll just give you a real quick example because we actually discussed this in our subcommittee. What if you look at a particular zip code and you say, okay, 40% of the narcotic search warrants are executed in that zip code. And of that, let's say you've got 15 to 20% of the drug prosecutions that achieve a conviction come out of that particular location. Well, compare that to the larger crime data statistics. Where are the larger amount of drug-related investigations and crimes occurring? If you've got a disparity between law enforcement's focus on that community, what the crime data statistics say versus the number of search warrants that are executed and convictions that are resulting. If there's a huge disparity there, you've got a problem. You've got a problem that law enforcement might be focusing too much on one community. Or if, for example, the number of search warrants and prosecutions correlate the larger crime data statistics for those zip codes, then those people who are speaking on behalf of law enforcement would say, well, wait a minute, the reason we're there is because that's where the crime is. You can look at the data and see that our investigative techniques match what you're looking at in the larger crime data statistics that are compiled. So I wouldn't necessarily jump to the conclusion that the data is going to work against those entities that are advocating on behalf of law enforcement or the government entities. I think that data can be used to answer the question. And that's part of what Denise was indicating. You got to know the history and you have to know what's actually happening so that you can have an honest conversation about it. And I think that can cut both ways.
Now, I will say, Sheriff Scholler, that as an example, there was an attorney here in my town advocating, and there's probably other people who have advocated that the entire process of a judge interacting with a law enforcement officer seeking a warrant should be on the record, quote unquote, and recorded somehow where somebody could come back and watch it later. And my argument to that has always been, if you don't trust me now, that all I relied upon was what was in that affidavit, you're not going to trust me that all I relied upon was what was on that recording, because I theoretically could still have a conversation and then say, okay, let's go on the record now. At some point, there has to be a trust, but this e-warrant system helps with that a little bit. It is essentially every bit of information the judge has is right there in the affidavit. There literally can't be anything else. I do think there's going to be there'll be occasional situations where there'll be a process where there'll be a back and forth to try to strengthen an affidavit, but that'll all be, everybody will know what it is, and there won't be any extraneous communications. That doesn't mean some people still won't trust us, and some people won't find something in the data that upsets them. At least we've got real data to work with.
Judge, if I may. Go ahead.
I was going to say something on a different topic, but it kind of goes to one of the points of your presentation as well. I think in terms of, I'm the county attorney representative, so what I'm thinking about is the ones that are denied. A lot of times in my county, those denials would not make it to the judge because we have law enforcement involvement with prosecutors. So I think that helps weed out a lot of that so that you're not having that conversation because they have that conversation with me. I would say the majority of our search warrants, I can't remember the last one that I submitted to a judge that was not approved. However, there have been plenty that have been tendered to me that I denied, or they called me during preparation and I said, you need more, so you keep going.
Yeah, it's not inconceivable to me that I would look at a warrant and say, isn't there more to your probable cause? And they'd say, well, this. And that Rob Sanders wouldn't say the same thing when he looks at one. I'm pretty sure he's going to have everything in that affidavit that helps, and just as you do. So yes, I think those things go kind of hand in hand. If we're going to go to this process, better to try to make sure it's right the first time in.
And I would also note on the statistical data, I think you are correct. The issue that is going to be hardest is going to be that last column, because that's going to be the column that costs the most money. I would just say if we do that, we need to make sure it's the same person or similarly situated person entering that information, because if we leave it up to 120 different areas, clerks, counties, we're going to get a variety of approaches to that. I'll also say I'm a little uneasy about whether a case was filed or not, because search warrants can often be charged day of, but oftentimes the more serious cases take longer. Sometimes they don't even get filed in our court. They might get filed in a federal court, so I would have some concerns over that. But I do think I think all of the data could have value. That might be the most value, but I don't know that we have to have that in order to go forward with it. And I just say that because of the financial burden of it. But
I think if I was part of a reviewing task force 3 years from now, and I was talking to the people going to bring us the data, I'd say on this date of execution, as opposed to giving us just number of how many haven't yet been executed, tell me how many, or let's say there was a column for it led to an indictment. I want to see how many for over a year now since they were executed haven't led to an indictment. In other words, I'd tell them to put a cushion in there. And my guess is they could do that fairly simply with a few key punches to deal with that particular thing. And again, I'm picking a year randomly. You could pick a different number, but you could build a cushion in there of time because of that very reason.
my concern with that again would just be who is going to do that, because I think clerks have a lot of other jobs they're being responsible for now, and I think if they're not charged the day of, that data is probably going to be left out. If you leave it up to the officers, I love my police officers locally, but a lot of them, I worry about them going back in afterwards once they get the signed warrant because they've got so much responsibility. So we're wanting to get empirical statistical data. I think that having the right person to gather that information and enter it is going to be an issue there unless we have a fund of money that will be responsible.
Yeah. And you probably won't fill in all the blanks on every search warrant. you will probably say, this month, this year, we want to look at such and such hard. And you might tell your clerical staff, go look hard at this particular subset and flesh out some things. And there's nothing that says you have to keep all of this stuff on everything, because a lot of it you're just going to say, we don't need to, that's not really our focus right now. This isn't anything that's causing consternation within the community.
Well, I was just going to say I'm 100% in support of prosecutorial review before it gets there. I started working on search warrants in 1980, and I don't know, I know nothing about search warrants in Jefferson County, but in Bullitt County, I started doing that then. And when I became county attorney in 1990, every search warrant that was done in Bullitt County was prepared by either me or one of my assistants there in the county attorney's office. And for 21 years, it was less and less as we went by because the police started getting trained in how to prepare search warrants. And it was our belief, and it still is mine today, that a search warrant itself is a judicial document. And I find no place in the statute or the rules that says that there is currently a role for the prosecutor. A person can go to a neutral and disinterested magistrate with their affidavit, and the neutral and disinterested magistrate is supposed to, as I understand it, look at the four corners of the document and make the determination. Now, as we take and say, as we question that law enforcement officer and say, well, what's your probable cause here? And then we start working on it, we're starting to chip away at our disinterestedness and our neutrality, perhaps. I don't know that for sure, but there's an argument that would be happening. So I think the e-warrants is going to help that. And all the ones, and I know back in the day when I was preparing search warrants, there were many times I was told at any rate, and the time or two that I got a telephone call from the judiciary where they said, did you review this? And I said, yes, or I said, no. And over the years, there has been 3 places where there was a screw up on a search warrant. It was either screwed up in the affidavit, or there was information in it that was improper or falsified or mistaken, or there was a screw up in the courts issuing it, or there was a screw up in the execution of it. And in any one of those, if the judiciary is that neutral and disinterested magistrate, that check and balance is already there, that the neutral and disinterested magistrate is supposed to and does, with great regularity across this country, review it and determine, yep, this is one that ought to be issued, or nope, this is one that's not. And I think that check and balance has been there since 1776, and you know, the Fourth Amendment and Section 10 of the Kentucky Constitution. So, but the prosecutor questioning the law enforcement officer is the more appropriate place to get that search warrant affidavit straightened out, because that's 2 members of the executive branch as opposed to the judiciary questioning the guy and then hacking away at that neutrality. So that's not a question, that was just a comment.
Thank you. Anyone else?
Anyone else with any commentary or questions for Judge Cunningham? I'm sorry, Judge Cunningham, have you all, whomever, have you all, or Mr. McGee, have you all made any sort of assessment on what the age of information? I mean, is it 3 months? Did you have any conversation about that at all? About what that range might look like?
I don't remember us doing that. To be candid, I don't even remember. I'm pretty sure the FBI guys said, this is our parameter, and I probably wrote that down on the agenda or whatever piece of paper I was keeping notes on. I will tell you, one time I thought lightning would strike me dead because I said, I may think I need the help of a law professor. And normally I have nothing but bad things to say about law professors, but that's a whole nother story. So I started hunting up, surely there's somebody who's devoted their research time to what are the best practices on search warrants and how does this work around the country? What are they up? And I honestly, I couldn't find anybody. And that's just a function of people do things their own way. And there could be a particular judge, for example, in Kentucky, whose attitude is, I don't want you to bring him anything that's older than 14 days. If it's 2 weeks old, I don't want to hear it. I don't know that to be the case. I'm just saying it's that idiosyncratic. Somebody could have their own little personal perspective of this is how current I want it to be. We haven't had a big conversation on that. And I, as I sit here right now, I don't have a particular opinion. I'd be happy to listen to the folks who have been in the process of putting together investigations. Tell us what they think is a fair number of time. In other words, in an ideal world, it would be as short as it could be without seriously impacting the ability of law enforcement to do their job. And I have no idea what that is because I have never done their job.
In large part, that's going to depend on what we are searching and what we are searching for. Because while if we're going looking for narcotics, 72 hours might be too long. But at the same time, if we're looking to search a cell phone that's been in a police evidence room for 12 months, presumably the data hasn't changed one bit since the day it was seized by police. So the probable cause would be just as fresh 12 months later as it was the day they took it into custody. And there's 101 different examples of everything in between. So I am hesitant. I mean, I think that it's so fluid depending on what the situation is. I don't know that this task force or any task force will ever be able to come up with a etched in stone timeline of this is how much time you have because there's too many variables in play.
So again, I'd go back in my notes and see what the FBI did, but I don't necessarily suggest that what rank and file police officers are doing in our state is the same as what FBI people are doing. And so to Rob's point, in some instances, when they're doing the same kind of stuff, that might be an appropriate standard. When they're doing something very different, you might need a completely different standard or no standard at all. So we haven't really delved into that. We just said it was something that we know some people are doing, and it's probably a best practice to try to have it in your mind when you're putting this stuff together.
Anybody else? Any thoughts, questions? All right, well, thank you, Judge Cunningham and the Securing Committee for putting together such a very thorough presentation and providing some recommendations. I think what we'll do is that we'll compile all these recommendations. I was looking for Blake, but and then I guess towards the end of our meeting, we'll make a judgment about how to move forward on each particular recommendation and perhaps even condense them down and ultimately decide, leave that to you on the side. But this is a great starting point, and I recognize that you all, Judge Cunningham, had the shortest amount of time to get prepared, and I'm grateful to all of you for undertaking diligence in getting this presentation together, getting as much information so that you all can make very considered determinations about recommendations to bring forth. So I appreciate it greatly, and I know by the number of questions that were asked and comments that were put forth, I know everybody here appreciates it as well. So thank you. All right, at this point, make sure I'm not missing anything, but I guess we'll break into subcommittees for further conversation on securing, serving, and reviewing. Imagine we have about an hour or so. If you need more time, let us know that as well. But we will allow you all to get to your meetings, and thank you all
and
for
I'm
taking
for the
minutes.
balance of my subcommittee, I'm saying goodbye. I've got to get back to some judging, but I look forward to the minutes.
Thank you, sir.
Thank you.
Thank you, Judge.
Thank you.
All right. Everybody feel free to go to your committee meetings. Thank you.
Can you change that hat?
Maybe.
This one?
Yeah, we'll put UK on there. WKU even better right now.
Well, no, let me tell you, and until they play the Wildcats in the SEC championship, roll tide.
All right.
When they play the Cats in the championship, then it'll be go Big Blue.
Always like to say that the greatest gift Boone County ever gave Alabama was Sean Alexander.
Roger that, sir.
You come up there breakfast with us. Come Saturday.
All right, I think we've got everybody back in the room or virtually. So at this point, we'll just ask for a brief update on the subcommittee meetings. Anybody want to take the lead for the security committee?
I'll be happy to. One of the things that came out of the securing committee is that we need to explore and ask you for the opportunity to extend the deadline past December 31st. We feel like there's a lot of work that needs to be done and that we've kind of had to do cram courses and trying to address some of the issues that need to be addressed. So that was one. We reviewed the reactions to the presentation and came back with some still issues that we'd like to meet and talk about even further. And one of them is exploring, excuse me, a standardized checklist that can be used across the Commonwealth and tweaked depending on the size of the community or city. But I think our major concern is next month is the next presentation, which takes us to October, then the following presentation, and then we're into the holidays, and we just feel like there's a lot more work to be done. So not trying to put you on the spot, sure, no. But
well, we can, sir, my hope is that we can, I don't want to meet forever.
No.
And so if, everybody, has a view of how much time is needed, part of the reason that I think we sort of settled on December was the idea that, if recommendations were to come out of here, and I understand maybe there's some other ideas about toolkits and what have you from maybe the serving committee, but, we wanted to have stuff that could perhaps be presented to the legislature, but, I don't know if we need to make a decision on that today. I guess maybe at the next meeting, we can make sure that that's on the schedule for conversation about perhaps extending on that front. Sounds like somebody was trying to talk there, maybe. No.
I think the general consensus is whether we get the extension or not, we feel like we need to have more meetings to iron out some issues. So we will give your office notification so they can make it public, whether they be Zoom or in person in Jefferson County, so we can continue to work and not violate any laws.
Sounds good. Thank you, ma'am. All right, anybody from the serving committee?
We pretty well determined that as far as the servant search warrants goes, we want to take and provide some tools that can be reviewed, and each individual jurisdiction and each individual agency throughout the Commonwealth take a look at them, a best practices sort of a listing. And we talked about putting something together along those lines. And another thing that was brought up in ours is that we in this state, and we in law enforcement in this state, and frankly, the folks in the judiciary and the folks in the prosecutorial offices and government-wise have not done a good job of publicizing to the public to provide confidence or lack thereof, either way it goes, and what the process is and has been for many, many years, for, again, going back to 1776 even. there has been a process for how someone is supposed to, how law enforcement is supposed to be able to get a disinterested, neutral magistrate to consider issuing a search warrant. That's been there, and it's worked pretty well over the years, as long as the various agents, the various bodies that are involved in it do their part. There is a check and balance there. We've not done a very good job of letting folks know what that is. So how many people out in the community are thinking that Judge so-and-so is having coffee and beer with Officer so-and-so, or how much of this and that, and don't recognize or understand that there is a requirement under the Constitution that that judge be disinterested in the process and be disinterested in the case and neutral to the whole thing as they review it. So we think, and likewise, the professionalism that the Kentucky law enforcement has. There's many states in the union that do not require the level of training that our police officers are required to have in Kentucky, and don't require the ongoing training that our officers have. And so there's many reasons that the body, that the people across the Commonwealth of Kentucky should feel very good about the professionalism and the professional training that their police officers have throughout, whether it be from Fulton County to Pike County, from Covington to down to Cumberland County, Kentucky, and everywhere in between. And so it was brought up, actually Dr. Wright brought up that we need to publicize that, because the general public may well not know it. But that, and primarily we're going to be working on putting some toolkit, some stuff that we would recommend getting into a best practices list of how we should get ready to and then carry out the execution of the search warrant.
Thank you so much, sir. Anybody have any follow-up for Sheriff? All right. Can we get an update from the reviewing committee?
For Sheriff, I know in Hopkinsville, our newspaper a couple of years ago did a series on the Bill of Rights, and they had a person write about each of the first 10 amendments to the U.S. Constitution. And I got to do the one about the Fourth Amendment and talked about the search warrant. I get to write this big old op-ed, and I hope people read it. It was not the most exciting thing in the world, but it kind of laid out the process. So we've tried to do that, at least in Christian County, a little bit to inform people on what to do or what we do. And second of all, I believe most judges are as disinterested as possible when it comes to search warrants. We have good relationships with police officers. We see them every day. We talk to them every day. Me personally, I don't go out and have beers with a bunch of cops, but I don't mind having lunch with them if I see them out or anything like that. I would like to think that they can be trusted and I can be trusted to do our jobs. So I think that's what most people think anyway. So we try to do our best with regards to that while still being human and civil. So. With regards to reviewing, I don't want to spoil all the fun that's coming in October. We have the presentation for the October 21st Somerset meeting. We've had some very lively discussion in our group. We are made up of prosecutors and Mr. Preston from DPA, and we've got law enforcement Chief Monroe over here, and we've got Chairman Massey and myself. So we've kind of got all the angles covered here. So you'll be hearing from each of us in October, and we had really good discussion going over these questions that were put forward to us. So we look forward to presenting our findings and our recommendations in October.
Thank you, sir. Any follow-up questions? Okay. At this point, I don't think we have any public comments. Any other thoughts or comments anybody might want to make before we wrap up? We'll make sure to put on the schedule next week a conversation, or next meeting, a conversation about whether to extend or provide additional meetings.
Thank you.
Make sure to do that. Anything else?
Mr. Rawson, I really appreciate you coming to the Central Time Zone. So I just wanted to say that. So.
And I apologize, it threw me off course. That's why I was not here. I was here by 1 o'clock Eastern Standard or Central Standard Time.
Understood. All right. right, well, with that, can I get a motion to adjourn?
So moved.
All right, any second? All right, all those in favor say aye.
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 Any opposed? All right, motion approved. Meeting is over. Thank you, sir.
Thank you all.